We'll come to order now and welcome everyone to the Indigenous and Northern Affairs Standing Committee of Parliament. We are meeting today on to hear testimony on Bill S3, an act to amend the Indian Act, specifically the elimination of the sex-based inequities in registration. And we have two panels today. The first panel is with us right now. We are welcoming four officials from the Department of Indigenous and Northern Affairs Canada. Joël Montminy, Assistant Deputy Minister, Resolution and Individual Affairs Sector. Welcome. Candice Saint-Aubin, Executive Director, Resolution and Individual Affairs Sector. Welcome. Nathalie Nepton, and forgive my pronunciation if I'm missing any. I look forward to learning the correct way. Executive Director, Indian Registration and Integrated Program Management. Welcome to you as well. And Effie Panousis, Senior Policy Advisor and Manager, Treaties and Aboriginal Government. And you are joined today by Martin Ryer, General Counsel from the Department of Justice. Welcome to you all. We're very pleased that you're here with us. We are happy to offer you 10 minutes to use amongst yourselves as you see fit. And when we get to about 9 minutes, you'll see me waving a yellow, and then at 10 minutes a red, and then we'll move into questions from there. So if you're ready, we'll just get right into it. Thank you.
Thank you very much. So I'm Joël Montminy. Je suis la sous-ministre adjointe du secteur des...
I'm the Assistant Deputy Minister of the Resolution and Individual Sector, Indigenous and Northern Affairs Canada.
Ici aujourd'hui pour pouvoir vous fournir des...
I'm here today to provide you with information on the government's response to the Deschêneaux ruling. As you know, our response involves changes to legislation foreseen in Bill S3, an act to amend the Indian Act, elimination of sex-based inequities in registration. And this will be followed by a collaborative approach on general linked issues.
In August 2015, the Superior Court of Quebec ruled that the provisions of the Indian Act violate the equality provisions of the Charter because they perpetuate residual sex-based inequities in Indian status. The Deschêneaux case deals with the differential treatment between the male and female lines in the acquisition and transmission of Indian status relating to first cousins of the same family and siblings. As a result, the court declared several key provisions of the Indian Act invalid and suspended its decision for 18 months to allow time for the necessary legislative amendments. Canada originally filed an appeal, but the decision, as you can see, came down during the election, but the appeal was withdrawn in February 2016 by the new government. So in order to comply with the decision, legislation must be passed by February 3rd, 2017. So in the absence of a response by this deadline, Canada will be unable to register the majority of individuals seeking status in the province of Quebec and possibly in other jurisdictions, as the key provisions in the INAN will be inoperative. So last July, the government launched a two-staged approach to respond to the Deschêneaux decision. As part of the first stage, the government started holding information sessions with Indigenous groups and introduced legislative amendments to the Indian Act through Bill S3 to eliminate residual sex-based inequities in Indian registration. The second stage will be a jointly designed collaborative process with Indigenous groups to examine the broader and systemic issues relating to Indian registration, band membership, and citizenship. The purpose of this process will be to identify areas for future reform. So before examining the proposed amendments in more detail, I'd like to provide you with some background on Indian registration to better understand the context for Bill S3. So under Section 6 of the Indian Act, the federal government exercises exclusive authority in the determination of who is an Indian. So eligibility for Indian status is determined on the basis of an individual descent from a person registered or eligible to be registered as an Indian. So prior to contact with European settlers, we know that First Nations had diverse ways of identifying their citizens, including clan, kinship, and hereditary systems. These were displaced as a result of the introduction of the concept of Indian in colonial and then Canadian legislation. Starting in 1869, patrilineal descent rules and sex-based criteria for Indian status and band membership were entrenched in federal laws and continued under successive changes to the Indian Act. Under these rules, Indian women who married non-Indian men lost status, as did their children. And through enfranchisement, individuals and their descendants lost Indian status if they became a doctor, a lawyer, Christian minister, or joined the military or earned a university degree. So in 1985, the Indian Act was amended through Bill C-31 to comply with the Charter. This was the first step in addressing sex-based and other inequities in Indian registration. As part of these amendments, Indian women who married non-Indians no longer lost status, and those who had previously lost status could be reinstated, as were their children. Enfranchisement was also abolished, and individuals who had previously lost status could be reinstated, as could their children. So the 95 amendments also introduced categories of Indian registrations through subsection 6.1 of the Indian Act, and also limitations on the transmission of Indian status after 2 consecutive generations of parenting with a non-Indian through subsection 6.2, and that's commonly known as the second generation cutoff. What's important to note is that second generation cutoff rule was implemented in direct response to concerns raised by First Nations during consultation on Bill C-31. Finally, Bill C-31 also reinstated First Nation authorities to control their membership through Section 10 of the Indian Act. So despite these amendments, some residual sex-based inequities stemming from the past were carried forward. New issues arose as a result of the introduction of categories of Indian registration. I've mentioned 6.1, 6.2, and that resulted in increased legal challenges. So the first case that was significant was the McIver case, which was decided by the BC Court of Appeal in 2009. In response to that case, Parliament passed Bill C-3, the Gender Equity in Indian Registration, which was passed in 2011. Bill C-3 amended some certain registration provisions to ensure that eligible grandchildren of women who had lost status as a result of marrying non-Indian men could then become entitled to registration. So basically extending the eligibility to one more generation. Following Bill C-3, the government also launched an exploratory process to gather the views of Indigenous groups regarding issues related to registration, membership, and citizenship. Over 3,500 individuals participated in this initiative, and the findings revealed a myriad of perspectives. So this brings us to Bill S-3, which proposes amendments to Indian registration to comply to the Deschenaux decision and to eliminate all known sex-based inequities. So Bill S-3 will amend Section 6.1 of the Indian Act to extend eligibility for Indian status to descendants of the female line. These changes will specifically address issues relating to cousins, siblings, and removed or omitted minors. So, and this is a bit difficult to describe just in words, so later on you can consult the deck that we've provided to you, and there's comparator charts on page 22, 24, and 26 where you'll be able to see the effect of the changes that I will describe. So the cousin issue relates to the differential treatment in the acquisition and transmission of Indian status that arises among first cousins of the same family, depending on the sex of their Indian grandparent, in situation where the grandparent was married to a non-Indian prior to 1985. This results in different abilities to acquire and transmit status between the maternal and paternal lines. The siblings issue concerns a different treatment in the ability to transmit Indian status between male and female children born out of wedlock between 1951 and 1985 amendments to the Indian Act. So Indian women in this situation cannot transmit status to their descendants unless their child's father is a status Indian. Indian men in similar circumstances can transmit status to their children regardless of whether they parent with a non-Indian woman. So, guided by the advice of the court to not take a narrow approach in our legislative approach, a third issue has been included in the bill. It deals with removed or omitted minors. So prior to 1985, registered minor children who were born of Indian parents or of an Indian mother lost their status, as did their mother if she married a non-Indian man after their birth. This is in contrast to their adult or married siblings who retain their status. So while Bill C-31 restored Indian status to women and their children in this situation, it did not make eligible the children of the reinstated minors. So the proposed amendments in Bill S-3 will address this issue and extend eligibility for Indian status under subsection 6.1 to the children of the reinstated minor child. So, les implications des modifications proposées, évidemment, comme on pouvait...
Now, the implications of this, obviously, there will be a greater number of people eligible for Indian status as a result of Bill S. There will also be a change of category for some of them who are already inscribed. According to the demographic analysis, between 28,000 and 25,000 individuals will become newly entitled for Indian status as a result of Bill S3. This increase will impact the costs of two federal programs that are directly linked to registration: INAC's post-secondary education program and Health Canada's non-insured health benefits program. The government's fall economic statement, released on November 2nd, identified approximately $149 million for the implementation of Bill S3, and the department is running an ongoing evaluation for the potential costs for post-secondary education programs. The change of entitlement may affect other long-term programming, and we will continue to review and evaluate the changes over time regarding especially the mobility of First Nations status persons who wish to go and live on reserve.
With Indigenous groups, and we heard a multitude of perspectives. Some concerns that were expressed were related to the short time frame for information session, limited scope of the proposed changes, the impacts of accommodating newly entitled members, and the narrow focus on technical amendments that perpetuate colonial Indian structures. Recognizing these concerns, the government is committed to the second stage of this initiative. The deadline imposed by the court of February 3rd, 2017 is insufficient to allow us to conduct meaningful consultation with Indigenous groups to address all of these complex issues in a short time frame. So in consideration of this, the government will launch in February 2017 the second stage, which will be joint work with Indigenous groups to address broader issues with a view for future reform. Thank you.
Okay. Thank you very much, Ms. Momini. We'll move right into questions now. These are 7-minute questions, and the first question is from Gary and Andisangri, please.
Thank you, Mr. Chair. Thank you for the presentation, and thank you to the panelists that are here. Some very specific questions with respect to the additional decision. And I know you discussed the issue of omitted minors. I'm wondering if you could maybe give us a sense of what other issues that may be in the legal pipeline that could potentially change or have us revise the Indian Act again in the near future, if there are any pressing based on the Deschanel decision.
Thanks for the question, Mr. Chair. I'll try to provide the information that I have. I do not have in front of me a list of the various challenges that we are aware of. I can point to a situation that we know about, but that is very complex to address. It's the situation where mothers do not know the identity of the father, and therefore this presents difficulties for registration of the child. This is one issue that will need to be considered and could potentially lead to changes eventually. We are also aware of proposed class action challenging the one provision of the bill which amended the Indian Act in 2010 with respect to the possibility of claiming damages for the lack of registration prior to the enactment of these amendments. And at the moment, these are the issues that come to mind. There are challenges to the act based on the Canadian Human Rights Act, which are similar to those presented under the Charter, and some of which will be addressed by these amendments.
In respect to the cost, I know there's some mention here of the cost of, I think, $130 million. And I think the numbers we're looking at is anywhere from 25 to 30,000 potential registrants. Now, would that include the cost of resolving a class action, or is that outside the scope of this? And what other and then what's the basis of you coming up with these numbers? What's the underlying what are the underlying data behind these numbers?
Okay. So it's outside of the numbers that Joelle had mentioned in her speech, and that you'd see before you around the 130 from the fall economic statement was actually around programs per individual, and it was related to the demographics. We did hire one of the top demographers here in Canada, Stuart Clatworthy, who was a part of the case, was a witness at the case at the time, and took into things such as fertility rates, mortality rates, et cetera, and provided us the numbers going forward, both in the immediate, which was the 28 to 35,000, as well as future across the upcoming generations of 50 years. And
with respect to the response from many of the communities, what's the range of responses you're getting, and what seems to be the prevailing sense with respect to this issue?
So the information sessions have provided a variety of responses. There are those who are obviously quite happy to see us moving forward on this issue, having been denied from the previous round of amendments. But then again, on the flip side, we have those who feel that we've perhaps gone too far, that we're taking our own ability to have sole authority over identifying and registering Indians and without some meaningful conversation. I think from what I have heard, the prevailing response has been the need to want to look at broader complex issues outside of just those identified in the case. That, I think, has been a consistent theme throughout our conversations to date.
Okay, and with respect to any resistance from communities in terms of accepting those who are newly registered, what are the mitigating issues that you will have in order to deal with those challenges? So if a community is not willing to accept a new registrant, what are the mitigations? What kind of mitigations have you thought about?
So with the regards to, that would be membership, we have the two groups of membership, being Section 10, where they have authority over membership codes, and then we have the Section 11. Those that are registered automatically for communities under Section 11 will be included in the band membership. However, for those under Section 10, that is outside the purview of the federal government, because we have devolved that authority and control to the communities themselves. So if there are any challenges, it's between the individual and the community themselves, because they own their membership.
Okay, and one more minute. Okay, with respect to, just going back to what other issues may be there, I know the Daniels decision is also something that is not directly related, but I know it's in the department's hands. Now, what if any changes can we expect, or can we anticipate with the combination of the Daniels and the Deschenaux decisions, where those parents who may be covered under the Daniels decision, do you see any implications to that?
Not directly. As you know, the Daniels decision dealt with the division of powers, so saying that non-status people fall under Section 9124. So there's no correlation to registration. But I guess the connection might be that a lot of these individuals may decide to seek registration under the Indian Act, and if they were to be made eligible by these amendments, then we would then be dealing with the same group of people.
Thank you. Thank you very much.
Thank you both. The next question from Kathy McLeod, please.
Thank you. And Thanks for the presentation. The first, your statement on page 7 that this will eliminate all known sex-based inequities. Are you confident that this particular, we're not going to have another, similar to my colleague, we're not going to be looking at another court case and another piece of legislation coming down the pipe? Is that, you're confident that we have now taken care of this as an issue?
So we are confident that with these amendments, we are dealing with all known sex-based inequities in Indian registration. It's not to say that there are not other types of inequities that are going to be brought forward by various groups. We do have active litigation on this, and it could relate to other types of issues. And I mentioned, for instance, the second-generation cutoff. So this is not sex-based. It's a policy choice that was made over the years to address the balance between individual rights and collective rights in terms of, and also maintain, I guess, to the concerns that you have with respect to this particular issue will be ethno-cultural erosion, for instance. So at what point do you have to go back to in order to address this? But in terms of your specific question for sex-based discrimination, yes, this bill is addressing everything that is known.
Thank you. My next question, comment, you said you started holding information sessions with Indigenous groups. I know I met with a number of bands in the riding I represent over the summer, and they showed me this letter, and they were, in this letter it indicated that that the department would be reaching out to them very early in the summer, and I think it was September, and they hadn't heard a word. So can you tell me what was your process for reaching out? How many sessions did you have? Where did you have them? Because I know that they were very concerned that this letter saying they would be contacted early, and then they were left hanging. So. Mm-hmm.
Thank you for your question. I remember seeing the email coming in actually on that issue. We started pre-engagement with the national organizations in early June, as well as disseminating information through the regional organizations. Given that there are so many individual communities, it was quite challenging to figure out the best way to do it. Following the announcement of our two-staged approach, we worked with our regional offices as well to ensure that we were going to the right regional organizations. In a province such as British Columbia, there are 3 or 4 organizations themselves, and we found that because of the number of engagements and consultations underway with regards in the federal government on Indigenous issues too, it was trying to find the right balance and timelines. So some came online a little bit later. British Columbia, I believe, happened about 3 weeks ago. We went back two more times, and we're continuing to go out over the course of the winter. In addition, we also tried to share information from the minister herself with the amendments posted attached to the letters, as well as posted online, so that we would try to figure out the best way to get the right information to those who are most impacted, and open to conversations and open to information and questions coming in. And we still are doing that. And again, that started in the very late summer. So we're continuing on the same in the same way of posting as much information as we can get online, as well as trying to email and mail and any way we can to get information out.
I know this one particular band was very concerned that
Mm-hmm.
this is an important piece of legislation. It had very significant impact on them, and they went into a great void over time, and so I think rightfully they were very concerned in terms of what the engagement process was, what the timeline was, and what they were led to believe it might be. So the next area, the technical briefing did not include numbers, but I see that there are some numbers that have now been attached to this proposal. So I'm glad to see that, and that was the $149 million has been identified in the economic statement. So I guess the first question is, if you look at the $19 million over 5 years to process and register, I guess that works out to about $700 an applicant. So I'm hoping that you can explain why $700 is going to be the ballpark of how much it will cost to process the applicants and what you're going to be doing.
The money isn't just to process the applicant. It involves the additional cost of, for example, opening up the envelopes, whatever additional costs are involved with processing the actual application. I think as registrar, when I came on board, one of the things that fascinated me the most, both as a bureaucrat but also as a registered Indian myself, is that the level of work that's often required in terms of doing the research. So people send in the application and the hours that are sometimes and days required to do genealogical research, as well as assessing the individual's application, make sure all the necessary documentation is there.
With McIver, the decision, so you've had experience, I would hope that that will help in terms of how this, this legislation passes, how that will proceed. In how many were impacted with McIver? How many then became registered with the bands? And how did you accommodate the bands that had this increased registration relating to that particular decision?
Thank you. In terms of individuals that were registered as a result of McIver or Bill C3, comes out to, as of today, 38,467 individuals. Now, what I should say is that that only includes individuals that were actually registered. There's a whole other factor of applications that still have to be looked at who weren't registered. So we still have to go through the whole work of assessing the file on an individual basis. And I'm sorry, I forgot the second.
So how many of them became registered with the band? And how did you adjust the band's base funding to reflect that increase cost that they had if they registered with the band?
I'm afraid we're out of time on that one. Perhaps the answer could come as an adjunct to another question. Thank you.
Okay.
Sorry for the interruption. The next question is from Nikki Ashton, please.
Thank you very much for being here today to speak to such an important piece of legislation. I'd like to begin by relaying concerns that I'm sure have come to your attention by the Assembly of First Nations from Quebec and Labrador, who did write a letter to the Prime Minister at the end of October, and they indicate in their letter, the AFNQL considers that the provisions announced by the government in reaction to the Deschenaux decision contravene the obligation to properly consult with First Nations, which rests with the Crown. They go on to say, the approach taken by the government seems to us contradictory to the commitment of the present government to work in the context of a nation-to-nation relationship. As you probably know, they are highlighting the lack of consultation with communities and as well highlighting the fact that many of the nations that they represent have a very clear, have a position that they in fact ought to be playing the role of recognizing who is or is not part of the nation. But all to say the major piece is lack of consultation. And I do know it came up from my colleague as well, but I'm wondering, do you have some concrete figures on how many First Nations were consulted? How many people as well you may have heard from, not just on a nation-to-nation basis? Because while I did hear the response earlier, it was quite general, and I'd like to hear some figures on that front.
And building off of Ms. McLeod's comment too, we can provide you information in paper. We can provide you some written, but just as an overview, we've had to date 11 sessions across Canada, of which there's a variance from 50 to 150 participants. To ballpark, I'd say I hesitate, right, because people were coming in and out, and for the issue of privacy, we don't collect direct information because a lot of these individuals were not registered members at that point. That is really our key target as well, right, to register those who are unable to participate. That said, we have had to date sessions across Canada, with sessions coming up in the two territories most impacted, Yukon and Northwest Territories. We do have a broken down chart with the number, and if it's chief, councillors, registering administrators on the ground as well, which we're more than happy to submit to committee as well for your reference.
Mm-hmm. Yeah, and I appreciate obviously obviously for privacy reasons, individuals may not want to be named, but I think what we're hearing here is that First Nations feel like as though they were not consulted. So it would be important for us to hear from which First Nations you did hear, and that kind of concrete information I think is is critical for the work that we need to be doing here. So my next question relates to resources, and I guess the question is, in 2010, for example, many witnesses with the changes at that time registered significant concern regarding the fact that proposed changes to membership was not accompanied with increased resources to be able to process these changes, and this is something that has also been flagged by leaders in this go-around as well. Is this something that is being dealt with by the government? Are there resources that are being earmarked for First Nations to be able to deal with the processing on their end?
So as my colleague was explaining, that yes, there are resources, and that was echoed again in the fiscal economic update. We did take that into consideration, in particular with the demographics and the cost of processing an individual application writ large, as well as, of course, the programming costs.
So in terms of the figures, so that's more broadly, in terms of how much of that money would go to the First Nations themselves, is more the question that I'm asking.
Right, for residency-based. So just with regards to programming and the numbers that we've provided, is there's really two tranches of programming. There's those that are federally led programming for registration. Those are the two that we've talked about, the non-insured health benefit as well as the post-secondary education. The other programs are the on or residency-based on-reserve programming. Based on the demographics and the trends analysis we've done, the impact will be quite minimal for those programs delivered on the ground based on residency. We do not see mobility on and off a reserve to be quite large based on the 1996 census data and the 2011 household survey, as well as, of course, the implications and trends we saw with C3. So we do not anticipate. It's been pretty stable at about 49, 51, and then 48. It's really quite consistent. So we're not anticipating a large mass impact on programming on reserve.
Okay. Would it be possible to share more of that breakdown in terms of the on-reserve resources that are being allocated as a result? And to the first part of the answer, and obviously it was echoed in the presentation, we do know that the 2% funding cap continues to be in place, which results in existing inadequacies in terms of services, in terms of infrastructure on reserve. Obviously, while we did hear about some of the funds that will be allocated as a result of this changes to S3, do you perceive, given the fact that the 2% cap is still in place, do you perceive there to be a challenge when you are now admitting so many more people to the membership of communities when in fact, services are ongoing services are already being frozen in terms of funding and don't reflect the current population numbers? Perhaps you could speak to that tension that's emerging.
Yes, so as my colleague mentioned, we will be, a lot of these programs where you're referring to the 2% cap are the programs that are delivered on reserve, that are residency-based. So we will be monitoring the trends as to whether this particular set of amendments will lead to an influx of population moving on reserve. Historically, that hasn't been the case. And again, there's 37% of First Nations who control their own membership, so they do get to decide whether or not these people also receive membership as a result of this. So registration is only the one step. So we will be monitoring this. It's at the moment, we do not anticipate that this will put additional pressure on these limited resources, but over time we will be adjusting if the case, if needed.
Thanks. We're out of time there. Yeah, but well timed. The next question is from Michael McLeod, please.
Thank you for your presentation. I did have a couple of questions I wanted to ask, and I'm curious as to how far this goes back to correct all the different changes that were made over the years. I know personally in my family there were a lot of issues on registration, but that came way back when the script and the treaty were signed. And I've been approached by people in my riding on bringing this to justice, because a lot of decisions were made at the time, either influenced by the church or the people in the Hudson Bay or fur traders as to who actually fit. Financial status was also considered. So I have relatives that are status, and I have relatives that are not status. And some became status because of their gender. Some became status because of their financial state. And now we're talking about reconciliation. But how far do we actually go to try to correct that? Because there was a lot of people that felt they should have been registered either through the local band council or band membership, or there's others that felt they should have been registered as Métis. So there's lots of questions, and there are a lot of people that have registered that were forced to register as Métis who did not, they feel they don't cede or hadn't ceded or surrendered any claim to, or any rights to the land. But their great-grandfather got $100 or something, and that was it. So I think it's a question that's going to come up, and I'm really curious as to how we'll deal with that. Or are we even going that far back? Is there going to be a side table or other discussions on issues that are not obvious through this?
Yeah. Well, on that, yes, stage 2 will be, of this initiatives will allow us to have a much broader discussion around all kinds of issues dealing with registration, membership, citizenship, belonging to communities. So we'll do that. But in terms of your question, how far back do we go? It's quite complex, and maybe I'll ask Effie to speak briefly to the history and this balancing act that has been taking place over the course of these series of amendments to the Indian Act, and how far back we've gone so far.
So the first statute that appears in the history is in Upper and Lower Canada, pre-Confederation in 1850. And it was the first definition that we saw of Indian, of the concept of Indian. And it wasn't about the definition of an Indian. Those statutes were about protecting the land base, essentially what we call now reserves. The definition of Indian in pre-Confederation legislation that we saw in both Upper and Lower Canada was very sex neutral. It was more akin to the rules or the criteria that First Nations, the nations themselves, had in defining who belonged to them and who didn't, and that continued till about 1866, 1867. Post-Confederation, we see the first law, which was the Gradual Enfranchisement Act of 1869, that basically establishes very patrilineal descent rules and sex-based criteria. It begins to exclude Métis, or those folks who identify as Métis, from registration. And it continued that way basically until 1985. And over certain amendment periods, in the Indian Act back then was being amended every 2, 3, 4 years. So the 1951 Indian Act amendments were very comprehensive, and they essentially established the system of registration as we know now, with an Indian registrar and status and non-status. And subsequent to that, the other reform that happened was in 1985 with the Charter being in effect and trying to address all the inequities that flowed essentially beginning in 1869 and flowing through the Indian Act all the way to 1985. So there were massive amendments in 85. I don't think folks could foresee how the Charter would operate vis-a-vis the Indian Act, because it was all new to everybody. And of course we had the constitutional amendments in 82 that introduced Canada's recognition of Aboriginal and treaty rights. So the interplay of registration, membership, individual rights, collective rights became a much more complex endeavor. Just in respect of Métis, we anticipate under Stage 2 that we will be speaking with Métis individuals and communities and the Métis Nation around deregistration. because as a result of the amendments that happened in 85 and in 2010, 2011, a number of Métis individuals became eligible for registration. They registered, but because the authority of the Indian Registrar to unregister somebody was removed in 85, they can't deregister and join their Métis collectivity, as is happening now in Alberta and in Manitoba and whatnot. So that is one area we'll be looking at specific to the Métis situation, and we hope to be talking with Métis folks under stage 2.
Yeah, I just wanted to point out the Métis and Northwest Territories are not represented by any national organization, so if you need any help, I'd be glad to provide you with some context. BC 31 allowed people to register, and everybody or most people anticipated they would belong to a band, be part of a membership, but it didn't. For a lot of people, it didn't happen. Ended up on a general list, didn't belong anywhere, and then they couldn't pull back out. Is that going to be looked at also? The issue of unregistering?
In relation to band membership?
Well, we have a whole bunch of people that is registered as members. This could also happen again, right? The issue of being registered as a status Indian, but you can't join a band. So then a lot of times people will realize they don't want to be part of it. They don't want to be categorized. No. They can't join.
And that is a phenomenon that's happened since 1985, because before the 1985 amendments, registration is eligibility for registration and eligibility for membership were one and the same. If you
we'll have to leave it there, I'm afraid. Sorry about that. Yeah, no problem. We're moving into 5-minute questions now, and the first 5-minute question is coming from David Yertiga, please.
Thank you, Chair, and thank you for the panelists for taking our questions today. And I want to just continue on with my colleague Michael McLeod's line of questioning. And we see that S3 potentially guarantees Indian status, but it's not clear how it will encourage bands to include these people within their organization. Is there any programs or any consultations planned to encourage these new members of First Nations to be part of whatever band they are linked to?
Currently, they are 37% of all Indian Act bands are under Section 11, right? 10, sorry.
10.
So 37% control their own membership. So they make their own decision as to who is a member of their band. So the registration under the Indian Act as Indian status does not necessarily automatically give them membership into a band. Canada does not. I mean, this is an amendment that was reintroduced in 1985, where First Nations were able to take control over the determination of their own members. So the government would not necessarily impose our views as to who they should or should not recognize as members of their band. With respect to all the other bands that continue to be under Section 11, it's automatic. Indian registration will give you membership into the community that you belong to.
Well, thank you. And is there going to be money attached? Obviously, there's if a lot of new First Nations people are going to be moving into a reserve. Is there going to be more money for housing, more money for programming? Because you know what, already a lot of their budgets are stretched, and any more strain you put on their budgets is going to be not a good situation. So can you comment on if there's any funding, and is it a percentage based on how's the numbers going to be calculated, I guess, would be a better way to ask.
It's a good question. At this point, though, what we've seen from the demographic trends is that there isn't a mass influx of people moving back on reserve at this point, based on what we've seen over the last 30 years of data coming in. That said, as Joelle has mentioned, it is something that we are going to monitor. Because we don't see this mass influx of newly entitled or newly registered and status Indians moving on to reserves, the impact of those on-reserve residency-based programming is not anticipated to be very much. Quite minimal, in fact. So we will continue to monitor it. If there is a massive influx of people who do choose to move back onto reserve, then that is obviously something that we will need to revisit.
Thank you. In my riding in Alberta, Fort McMurray, Coal Lake, we have a Métis settlement, and we have, and they have cousins and relatives on both sides.
Mm-hmm.
So obviously, some of these people in the Métis settlement will qualify for status. The question is there going to be additional funding for the Métis settlement to provide programming for the First Nations individuals who decide to stay in the settlement?
So if they are registered and they choose to stay within the settlement, they would, as status Indians, would still be able to access non-insured health benefits, as we've indicated as well. But there will not be more money for the settlement themselves, the actual geographical location for their programming. It would be residency-based programming is provided to those who move on to the reserve. So housing, infrastructure, and stuff would remain for those on the reserve themselves.
Okay. Yeah, just and another question regarding the numbers that we've seen here. 28,000, 35,000 people are anticipated to register for Indian status. So how is this number? How did you arrive at this number? Because I think that might be a little low from my perspective. So is there a scientific method you guys use to achieve these numbers?
Yes. Oh, sorry, very short, yes. So they used criteria such as fertility rates, life expectancy, rates of entitlement from previous amendments that we saw in McIver as well as 1985, as well as there were specific cohorts based on age. So we do actually have a breakdown by the amendments themselves. So siblings would see approximately, siblings would see 3,000 potentially approximately new registrants. Cousins would see approximately 26,000 registrants. And then the omitted minors, which is the third one, would see approximately 500 people.
Okay, thank you.
Thank you. Next question from Don Resnack, please.
Well, thank you for coming. I've traveled around my riding quite a bit and had been involved in Grand Council Treaty 3, the northwestern part of Ontario, which butts up against Minnesota and Manitoba. The First Nation community, or the Indian Act Band First Nation community of Buffalo Point, has come up several times in my dealings with Treaty 3 and the legitimacy of some of their members, their duly elected chief and council. And I don't know what history has gotten the community into the positions it's in, but it would seem that if that is that's the leadership that the government's responding to, that having that leadership add, and I don't know if he has the power or his council have the power to add members, it would seem that they can add essentially voters. Has there been any discussion in the department regarding problem communities such as Buffalo Point? And I only mentioned Buffalo Point because it's something that's come up on my radar when I worked at Grand Council Treaty 3. And now it's coming up again on my radar as the Member of Parliament for the adjacent area.
Thank you. The issue of Buffalo Point and the history around elections and its membership, the department has in the past reached out to provide support or offer support in terms of trying to support the community in maintaining its membership list, because the registration list and the membership list are two different things, as my colleagues has explained. In terms of the elections, as you pointed out, the election list is based upon the membership. And the community itself doesn't conduct its elections under the Indian Act, if I'm not mistaken. They have their own election code, which further determines who has the right to participate in the election as a voter as well as a candidate. And so those rules are definitely within the purview of the band to determine, but the department is always available to provide support when it's sought by leadership. So I don't know if that answers your question in full, but
It would seem to me that it's just a mixed up system. I don't know for sure what is exactly going on there. I know there's been complaints by people from the community that their votes are being subverted. Their sometimes membership is not being recognized because an individual or a group of individuals are purposely making sure that they don't have effect on the outcome of the election. I know that there were criminal charges against the current chief. I don't know what the stage of or how they ended up. I have been told that perhaps that they've been dealt with, but there's questionable things going on with regards to registration in that community, and it seems that the answer we get, and I know there's other communities across the country, the answer we get from the department is, well, I'm going to wash my hands of it. They have their own traditional system, and they make the decisions. And when there may be really problematic inequities in terms of who controls the finances coming from your department and how they use that to influence vote and influence power within the communities.
I understand what you're saying, and when I look at my work when I was in governance and as well as my work as registrar, for communities that do control their membership under Section 10, as well as those that have their own election codes, for anyone who feels that their rights are not being protected or not being valued, the courts are generally their best venue or their best avenue for recourse.
Yeah, and that.
Well, we're out of time there, Don.
Expensive proposition, and a lot of the people who are in desperate need don't have the ability to do that. But I'll leave it at that.
Arnold Mearson, please.
Thank you, Mr. Chair, and thank you to our guests for being here today. Staying in on the registration, you said with the MacGyver case there was about 38,000 have been registered so far. What is the backlog from the MacGyver case yet? Is there still some more cases to come through with that one yet?
I'm sorry, a backlog for C3?
Yeah. C3, yeah.
Okay. For registrants seeking to be registered under C3, the process, as far as I know, hasn't signaled that there is a sufficient or a significant backlog. I can confirm that in writing to the committee later and provide you an exact statistic.
Okay. With the Daniels case, how many people are you anticipating registering through the Daniels case?
Again, with Cap Daniels, as my Assistant Deputy Minister indicated, is that it deals with jurisdiction. So essentially anyone can apply to be registered today, regardless of whether the Cap Daniels decision was issued. Registration is there under the Indian Act to register within the legal parameters of the Act.
Okay. So what is the current backlog at right now? How many cases are you working on right now?
Active
cases.
I'm sorry, I don't have that statistic, but we can definitely report back on it.
Okay. And what are you doing we're anticipating 25 to 38,000 people applying. Are we going to be able to manage that coming through the office?
As indicated, there is $19 million set aside over 5 years future to deal with registration of those that will become entitled as a result of Bill S3. Definitely, when we look at lessons learned from C3, we'll take what we've learned and apply that, because that process went very well. However, that process can't completely be transferred. For example, as Madame McLeod indicated, or a question is, $700, I think, was the figure she provided to process a file, is that when we process the file, we go from A to Z. We also look at, as I indicated, genealogical research that's required, as well as other administrative issues. So, for example, again, everything from requesting additional information of provinces, also looking at what's required potentially in terms of vital statistics, trying as much to assist the person who's seeking to be registered under Bill S3.
Okay. Mr. Chair, I'd like to share the rest of my time with Kathy.
Thank you. And I just wanted to pick up on the sort of the preliminary registration and then the appeal process. And I'm going to give you an example. There's someone that was turned down through your preliminary process. There's an appeal. She's 80 years old, and she's been told she has to wait for a year to have the appeal heard. So I'm very concerned and very interested in hearing, again, you have only so many people dealing with registrations as it is right now. Tell me about the appeal process and why the waiting time would be so long, and again, for an 80-year-old woman.
The protest period, of course, like the application files, vary on the complexity of the file. So it's difficult to provide a range within which a person can expect an answer. However, I can say that, like, for example, in the case of this woman that you've cited, I do have the discretion to ask for files to be pulled, to be dealt with on a priority basis for medical reasons, age. And so, if she would consent to you acting, for example, on her behalf to get information, that would be something that I would entertain.
So for my clarity of purpose, because we will be having a lot of people, 25,000 plus, with McIver, how many people applied, were turned down, and then entered into an appeal process, and what kind of time frame did that, and how many were approved subsequently on appeal, and what kind of time frame did it take?
I do not have the protest rates. I can undertake to provide them to the committee in response to your question.
Thank you.
We're out of time there. Okay. Well, in fact, we're out of time for this panel. So, on behalf of the committee, thank you very much for your time and testimony. Very enlightening indeed. We'll see you again, I'm sure, as the days and months wear on. We'll have a short suspend. Okay, we'll come back now. And welcome to the next panel. Thank you for being with us today. This panel is comprised of two speakers. The first is from the Abenaki Band Council of Odanak, and that's Rick Obamsawin, the chief. Welcome to you, Chief. And speaking as an individual, Stéphane Deschenaux. I'm glad to offer you each 10 minutes to address the committee, and I don't know if you've talked amongst yourself about who would like to go first. Is there any preference? Mr. Deschenaux, are you prepared to go? Okay, well, I am happy to give you 10 minutes, and when you get to about the 9th minute, you'll see me hold up a yellow card and then a red card at the 10th minute, and if you could wind up at that point, that'd be much appreciated.
Good.
But thank you very much and welcome.
Thank you. Well, first I want to thank the chief, the lawyers, and also the judge who took care of that case, because it was kind of a funny, excuse me English, sometimes I heard because I learned it on the ship, so I tried to cut some words off. It was funny back then because sometimes we used to be sitting with my cousin, and we were talking, and I was finding out that I have some cousins, their kids, they were registered, and mine wasn't. So we started, to draw some drawings, start to look it up, and so finally we find out that because some of them, they were having dads instead of mothers, they were having the cards, and mine weren't. So before I start to think about going to the band to put the flag on that, they came to me because they also find out those situations were some kind of funny. And the lawyers and the people of the band and myself, we proved that there was iniquity with that. I'm pretty happy with the decisions of that. But the point is, what I found sad today, that I find out last week that we were asking to come here already to talk about that, but we never been called up or being asked which way we saw about that stuff. And I even found out earlier, having a coffee with the chief and David, that there were even other stuff that we find out. Well, they found out that wasn't touched, or they were just, we didn't want to see them because they were only going by the rulings. And that's the part I find funny, because after what I thought, I have understand from the judge ruling that it wouldn't be in consultation. I was thinking they would come to the band and meet us and saying, like, we're going to go that way, or we're looking to go this way. Doesn't seem it's been like that. And I don't feel great with that, and I guess the chief and the lawyer either, because we find that funny. Like, we have, there you go with that, and find that funny, because we were the people involved in first of all, and we just learned last Friday they were right at the baby is born, if I can say. That's my point. I'm happy on one side, but disappointed on the other way, because I can't understand, like, we had it in our hands. Well, you had it, and we couldn't solve lots of problems. And again, we just went for a few cases, and maybe we didn't want to see them, or maybe the people didn't think there was other cases or other stuff that wouldn't have been put away or forget, or didn't want to be seen. So that's how I feel this morning, because for what I went through, and lots of people in my case, and even for my kids, that they won't have to go through, because just try to figure out, you spend 46 years of your life asking yourself, what I am. Do I am a white person? I am a native? And then someone's come up and say, yeah, you have the rules, you have that. The decisions were made. Like my mom's get it back, my grandmother's get it back, and I cut it back away for my own daughters. And then I find out there's the people, they're going to stay, they're going to ask themselves those questions again, because it doesn't seem to be put on what we're going up to now. I'm all yours.
Okay. Thank you. We'll go right to hearing from the chief first, and then we'll go to questions after that. So please, 10 minutes.
First of all, I'd like to thank you for having us here today. I know everyone is busy, and this is a very, very complex and complicated subject, and it gets deeper and deeper all the time. There's many cases that if we can show part of the power presentation after, we'll show you the basis on how the status system works. Some of the major problems with the status system was based on families. It was on gender. But there was much more to it than just that. In my own family, if I can just briefly tell you, in my own family, I have 4 children. And my oldest son was a 6'1". My second daughter was a 6'2". My third son was a 6'1", and my fourth child was a 6'1", only having one child with less status than all the rest. Because I had 2 children prior to '85, and I wasn't married. So yes, we tried to cover this in 2 cases, in the MacGyver case and in Susan Yanta's case, which solved this problem. The reason I'm saying that is because there are several problems with the status system. When we took the cases to court, we understood the ruling was very clear, that we all wanted to solve this problem. We wanted to solve everything now. I had said several times there was no rush. We needed to make sure we went through every single case and to see what the problems are. For some reason, they seem to want to be in a very, very big rush. I had told them, I said, if you come to us and ask us for an extension, we'd be more than willing, because it's a very costly thing to do all of this for all of us, for the government and for us. We don't want this to end up back in court again and to start over again. It was very, very clear in the decision that this was not supposed to be based just on gender. We were supposed to look at all the cases and try to close the files. They put a time limit on it. I said to them several times, if you need an extension, we'd be more than willing. They told me that they weren't interested in it. They didn't need an extension. I told them just yesterday on the phone, if we close this file in February, I will be back in court March 1st on 4 other cases. The answer was, that's your prerogative. You can do that if you like. I don't believe that's a proper way for us to solve these problems. I think the door's open now. Why don't we all sit down and discuss and solve the problem we have? It's time to say, let's put all of this behind us and sort it out once and for all. We don't want to spend the next 10 years in court again. We don't want to keep bringing up case after case after case. We have the time to do it. Let's look at all the cases at this particular time, and we can try to solve this. Several things. They told us that we were consulted, that they did consultants with chiefs last summer. I have not found one chief that they've consulted with. They've never consulted with me, and it was our case. They never even called us. So I'm trying to figure out how this was all got to this point, and now they're saying, oh, we're going to close this file, we're going to get it all solved by February 1st. And again, I've asked. I said, we have other cases that we want to bring to the table and solve under this same thing. No, we are only dealing with sexual gender at this time. We can go into another stage. We can carry this on later. Well, I don't know about anybody else, but why wouldn't we? The door is open. We're at the table now. Why do we want to spend more court time, more money, more of all of our time fighting the same argument that we're already at the table, that we could solve these problems and put this thing to bed once and for all? Thank you.
Thank you very much. Well, we'll move into questions from the members now. And the first question is coming from Mike Bossio, please.
Thank you both so much, or all 3 of you, for being here today. We really appreciate your testimony. And I guess I'd like to throw it open to, we understand the government wants to do a 2-phase process, the first one coming in February 17th, the second one being one more of a consultative approach. I don't know, I'm not going to argue the merits of one versus the other. What I guess I would really like to know is, what do you view as proper consultation and consent in this process?
Well, first of all, if I could just say, today is the first day I've heard of stage 2. Okay, and I heard that because I was listening to the last session. So, what is their plan for stage 2? I don't have a clue because we've never even been told about it before. You know, I don't understand why, like I said, we want to go into stage 1, stage 2. We have the opportunity now to solve these problems. It's just a matter of sitting down and discussing it and saying, where are we going? And let's close the file once and for all. I don't understand the point of saying, well, let's close this part, then we'll go into stage 2. We've seen the impacts of 85. We've seen the impacts of MacGyver on our communities. How many more impacts do our communities have to go through before we close this?
But what do you feel would represent a proper consultation process to go through with yourself, and how do you see that unfolding ideally?
I think that it would definitely work if they would come and consult us. But like I said, we've been consulted on nothing since day one. So if you're saying that we're going to go into stage 2 and we're going to go into consultation, this would be nice.
Well, that seems to be the intent from what I've heard as well as you've heard. But once again, what does that look like?
Just going to David add something?
Yeah, please, David.
May I add something?
Yeah.
It's important for this committee to know that after the 1985 amendments, there was a 1988 review. That 1988 review specifically talked about the siblings case, Susan Yanta's case, that produces children of the same parents with different status. They said change that. 1988. 2015, I was still arguing about it in court with the lawyers of the people that just testified. 2010, MacIver, the amendments because of MacIver. Indian Affairs said, there'll be another stage. We're going to consult broadly about membership and status. We asked the witnesses for the Registrar of Indians on the stand in the Deschenaux case, what happened to that? They said they didn't know. A few months ago, they finally published their report. That was 6 years. So I hope you understand that when the Department of Indian Affairs offers extra stages for broad consultation about all sorts of issues, I hope you understand why First Nations communities are skeptical.
Oh, I do. Given what we've heard just in the last year, from a number of witnesses that have come forward, yeah, we understand and appreciate the level of frustration that exists with Indigenous peoples, around long-term stable funding, around self-government or community-driven programs and priorities, and the whole consultation and consent approach. But once again, I want to try and get it on record if possible. How much time do I have?
You've got another 3.5 minutes.
Okay, so I'd like to try and get it on the record what you feel that consultation process should look like, and how extensive it should be, or I don't know if you can. I don't know if that's a question you can even answer, but I'd like to at least get your opinion on the record as to what you think that should look like.
I don't have a mandate to speak for the 600 communities. I can tell you in our PowerPoint, we've given you, and obviously we can't take you through all of it now, but we've identified 4 other scenarios where siblings can have different status, where first cousins with the same ancestry can have different status. That was what we thought, given the short timeline, that was something that the 2 Abenaki communities and their tribal council, the Grand Conseil de la Nation Wabanaki, had identified that they wanted to bring up with Indian Affairs and work through. That didn't happen because suddenly there was a bill before the Senate. That was also without notice. If the committee would like, I can briefly explain it. But there are still situations that to us seem totally absurd. First cousins, siblings, different status. The system doesn't have any credibility if it produces those results.
Now, we've also heard, that Indigenous nations should decide who's going to be a member, who's not going to be a member, and others saying, so you've got, band chiefs, you've got hereditary chiefs, you've got national chiefs, you've got regional chiefs. Where do you feel that the determination as to who would be registered as a status Indigenous person in Canada? Because I'd also like to get that on the record as well to try to support your position.
Well, first of all, there's definitely a very big difference between status and citizenship. So I think that's the first thing we need to clear is that with the status system, yes, Indian Affairs determines who receives status and who does not receive status. Depending the community and how that community operates, whether they have their own citizenship code, as you heard of earlier, under Chapter 11 or Chapter 10, it falls completely different, okay? So some communities will turn around and say that they will control their own citizenship code, and they will say whether or not status members are a member of their community or not. Very complicated. Other communities say, well, no, if they're status, they're definitely a member of our community. I can only speak for my own community. In my own community, if you have status, no, we will not turn you down. You are definitely a member of our community. We do also have a citizenship code of our community, so our citizens are also recognized in our community.
If I may add something.
Sure, please.
Sorry, we're out of time there. Cover it in the next question.
Sorry.
And if I just take a moment, I'm sorry, Mr. Schultz, I'd just like to introduce you to the committee and your role, if you wouldn't mind.
So my name is David Schultz, and I was the lawyer for Mr. Deschenaux, for Susan and Tammy Yanta, and for the two Abenaki communities in the Deschenaux case that led to this bill that's before you today.
Okay. Thank you. I have to just sort of describe a rule that we operate under in the House of Commons procedure and practice that if you're here as counsel, it's meant to be that you assist and aid and counsel the witnesses, but you're now testifying yourself. I expect you would find some flexibility among this group, but I just wanted to make sure we all understood the parameters there. Thank you. The next question is from David Yurdiga, please.
Well, thank you, Chair, and I'd like to thank the witnesses for participating with us today. You know, just the first question is the Chief. When did exactly you find out about S3? Because I was kind of shocked to hear this is sort of like, hello, S3's here, welcome, come talk to us. So that's shocking to me. So I'd like to get that on record. When did you guys exactly find out about S3?
If I want to be really fair and really nice, I'm going to say 2 weeks ago. But I don't even believe it was 2 weeks ago, okay?
Yeah.
It's like even for this particular meeting. Well, I only knew about this Friday at 4 o'clock. And I have a 4-hour drive.
We appreciate your efforts and coming up here in such short notice. And so, prior to being, coming to speak with us, would you have liked to see a process where you guys were engaged before we even come to this level? Because obviously we want to hear from not only you, but the perspective from your community and other communities. Because, my line of questioning was originally going to be on the consultation part. So that's out the window. So I'm going down a different avenue now.
We definitely would have appreciated, to have had discussed beforehand and talked about this. Matter of fact, they met with us at a Chiefs Assembly, and we requested it. And then this was the next thing we heard. So there hasn't been any communication whatsoever. And I think this is one of our biggest complaints about this whole thing is that, even in the Chiefs meeting, we made it very, very clear that they were just there to speak to us and give us an update. They didn't really give us much information. They basically just, said, well, we're working on it, here's where we're at, and we'd get back to you. And the next thing we heard was like I said, about a week ago, and I'm going to say 2 weeks to be fair, okay, that this was passed. And it made no sense to us.
Well, thank you. Like we heard some numbers that there probably be 28 to 38, I think, I forgot what number it was, but anyways, over 28,000 people potentially seeking Indian status. Do you have a feeling of how your community will be affected? Obviously, there'll be people in your community, and then some of them potentially want to become members of your band or your community, and obviously, there's got to be money attached to it. I mean, if you're gonna have people relocating, or actually, you don't even have to live there, but you'd be seeking services, from whether it's a school or whether it's the recreational facilities or whatever it may be. So, do you think there should be a program out there to address the financial burden that might be potentially your community might face?
Again, at the Chiefs Assembly, we've asked for this program several times. We're told that in the winning of the case was based on status. It wasn't based on financial commitment. What has this done to our communities? I figure within less than 5 years from now, I will be completely broke in my education. Healthcare is going to take a very, very hard hit. Although the members are gaining their status back and we have new members and new people applying in our band and we're accepting them all, we have no additional funding for these people, which is causing a very big financial burden on our communities. And like I said, that we've asked several times if there was going to be new funding, if there was going to be anything on it, and at this point we're told no.
So do you think S3 is going far enough? Is there some areas that are not being addressed? Because obviously, S3 will address some of the issues, but is there going to be some complications as a result of it?
I'm going to let David answer that.
With the chair's permission, I'll try and do this very quickly. We've identified at least 4 scenarios where there will be very odd results even after this. This one is where a woman lost her status. Either she gave up her status through what was called enfranchisement before marriage, or if she was under 21, her father could have given it up for her. So, for instance, there's a woman in Odanak who lost her status at 20 because her dad decided to enfranchise the whole family. She's a 6'1", her son is a 6'2", her grandchildren and great-grandchildren have no status. If she had her older sisters lost their status through marriage. They benefited from McIver. Their children are now 6'1s, their grandchildren are 6'2s, and post-Deschenaux, their great-grandchildren will be 6'2s. So we're going to have, the only difference between them is whether they were enfranchised at 19 or 21. Men who chose enfranchisement. There were men who, there's at least one family like this at Wolinak. Man marries a non-Indian woman, has a few kids, chooses enfranchisement, gets his status back in 85. So do his children, born before the enfranchisement. They're all 6'1s. His child born by the same mother after enfranchisement is counted as having only one Indian parent, so that child's a 6'2. So he has some grandchildren 6'2 status, some with no status, same number, same degree of intermarriage. And then unstated paternity. Before 1985, if a woman didn't declare the father, he was presumed to be an Indian. Post-85, he was presumed to be a non-Indian unless it was proven. Another family at Odanak, a woman, because before 1985, some women chose not to get married and not to identify the fathers to keep Indian status for their children. That's what this woman did. So her kids born before 85 are 6'1", her kids born after 85 are 6'2". Her grandchildren by the older kids have status, her grandchildren by the younger kids don't. And then the final case, legal adoptions. Before 1985, an Indian family that adopted a child, that child was only also an Indian if it was if its own natural biological parents were an Indian. So another family at Odanak, that a natural child, they adopted a child out of the orphanage, out of the cradle. That son didn't have status till 1985. He got married before 85. His child is a 6'2". The daughter, who is the natural-born daughter, her child is a 6'1". So that's 4 scenarios where first cousins have different status with the same number of Indian ancestors. and 2 cases where you can have siblings by children of the same parents with different status. Those are some of the scenarios we'd hope to raise with the registrar. Apparently, the registrar is not interested.
Really?
So in answering your question, does the bill go far enough? No.
No. So how much time I have left?
You're well over. I beg your pardon. So thank you for the question.
Well, thank you for the extra time.
The next question is from Nikki Ashton, please. Thank you.
Thank you, and thank you very much for your very powerful presentations. I almost wish we'd heard them first to really place just how serious the situation is that we're facing. I guess my question both to you, Monsieur Deschanel, and to you, Chief Obamsawin, is relates to the sort of bigger picture that we're discussing here. So the UN Declaration on the Rights of Indigenous People expressly forbids forced assimilation. And Monsieur Deschanel, you spoke about your personal questions and those of your children about who you are and what this means for your identity. Now, having heard the way in which this process around S3 is unfolding, hearing about the lack of consultation, hearing about, just the fact that you heard about this, as you put it out, being kind 2 weeks ago. And we're hearing from other First Nations. We've heard from the AFNQL that they are expressing serious concern about the lack of consultation as well. Can you expand on how you feel about this process and how it relates to that question of forced assimilation? Et vous pouvez répondre soit en anglais ou en français.
Well,
You're welcome to respond in English or French.
I got a phone call last Thursday asking me to be here today. Then I called David. I started to talk about David, about what we were doing. In my head, for me, it was like the start of the machine. Like, we're going to start to talk about things and stuff. Like, you think you need money, you need this and that. And David talked to me and said, where are you going Monday? I say, I'm going to Ottawa. So I send him the email I got. They never had it because we have the one from tomorrow morning. Then and I asked David, he said, is that going to be the starting after the ruling? Like, we're going to start to put the table and we're going to talk about that, this and that. We should cover this. That stuff we don't. And then we end up with the project almost done. So I was like in the shock. So I figure those people who are higher than I am, they must have been, That was the feeling of what I got this morning when I get there. It's like something was cut off or was missed somewhere.
Mm-hmm.
Rick?
Well, to be honest with you, the feeling I get is that one more time this is just going to be pushed down our throat and we're going to get whatever they give us. We've asked several times, like I said, to discuss the matters. We're told that there's really nothing to discuss. I even said, and I was actually a little bit blunt in the chiefs meeting. I had said to them, you're trying to rush this thing too fast. You don't have the time to do what needs to be done. And I said, why don't you just ask for an extension? And she said, well, why don't you ask for one? And I said, well, I can't. I said, the reality was we won the case. I would look foolish if I asked for an extension. But I would be more than willing to say that we need an extension. Because the feeling I get is that although we talk about the Human Rights Act and although we talk of all these things, at the end of the day, it seems like Indian Affairs is going to say, this is what it is. You don't like it? Take us back to court and fight again. I just find that process ridiculous. I'm probably one of the chiefs at the table who is strongly known for negotiations. I'm a strong believer if we all sit down at the table and we talk. And, we're not going to solve all the problems of the past, and we never will. But it wasn't us who made these problems. It was our ancestors who made the problems. I think today we need to sit down and say, what is the future, and how are we going to work together? And I feel, once again, we're not working together. There's still, Indian Affairs is here, we're here, and there is no discussion. To hear of things last minute is ridiculous. Like I said, I was told about a conference call last Friday that we were going to discuss things. I thought it was a conference call on discussing, we were finally going to sit down and say, okay, where are we going? What are we going to do? The call lasted all of about 15 minutes, and the call was to tell me to be here today. That's what the call was about. And I thought, So I said to her, I said, well, hang on a second. What about all the stuff we discussed in the Chiefs meeting? What about all the stuff we talked about? Did you guys ask for an extension? Nope. I said, you know that we'll be back in court. Oh, that's fine. Well, I don't know. I just think it's the wrong way of approaching this, okay? We're here at the table. We're willing to talk. First Nations communities are saying, listen, there's a problem. The government's saying there's a problem. Let's sit down and solve this problem once and for all. Let's stop going to court. Let's stop fighting with one another. It's ridiculous. We're wasting my time. We're wasting your guys' time. You know, and all it is a matter of a group of people saying, let's do this right the first time. And I don't understand. So how do I feel? I'm very angry about it. I know the other First Nations chiefs are angry about it. We're saying, once again, same story.
Thank you. How much? Sure, just quickly, you may have heard, Chief, that in the presentation by government officials, there was a reference to the department continuing to assess the potential cost increases of S3 on the post-secondary education program and its funding approach. We know that the 2% cap with respect to sponsorship at the post-secondary level continues to be in place. You know, a statement like this indicates that, that certainly there are no figures with regards to the additional needs. Does this statement concern you? Do you think that this is a major concern that both warrants an extension, but also is this something that that we need to take very seriously as parliamentarians?
We definitely need to take this very seriously, because, and one, I find it very, very hard to believe that when she said, you know, well, we don't have any figures. Well, I was a little bit disappointed that she, I mean, I know I'm only sitting in the audience, but I was a little bit disappointed that she didn't have any figures. I think they should have come a little bit more prepared. We know what the impact is. Each one of our communities have already felt the impact. We know how many. In my own community membership, I have already over 400 new members. I'm expecting close to probably 1,600. So it's not hard to do the math. And to them, they're saying, well, no, we don't have any figures. They, and I don't want to back up, but you know, I also heard them say, well, you know, we're, you know, we have so many members and we're behind in our registration of our status. Behind. I have members applying for status today, and it takes 2 years to get your status. And they're telling me that, well, we're not really behind. We have, you know, we have about 35,000 people that are registering. I think they're a lot further behind than they think, you know.
Thank you. And the next question from Don Resnick, please. Passing to Joel Lightbound. Thanks.
Mr. Chair, and then I'll share the rest of my time with Mr. Rosnack. Merci d'être ici aujourd'hui.
Thank you for being here with us. I have a brief question about the extension that you're asking for, Chief, and Mr. Deschenaux. The Superior Court judge recommended the government identify and solve other discriminatory issues that might be problematic, not only those covered in Bill S3. Were you provided with any reason as to why the approach was going to be more restrictive, more narrow, and there would be no extension requested? In my case, as I said earlier,
Been sitting with people to talk about that, and the first call we got, that's to be here today. So someone somewhere lost the puck, and we end up in here today finding lots of blind stuff, like, oh, how come nobody talked to us about that? When nobody never came to us to talk about that. And even for, like the chief said earlier, I wasn't a case for myself and my kids and my own brothers and sisters who fell after me, got their cards before me. So I tried to figure out what's wrong with the machine. But something's wrong somewhere, and we have an example later today again. For me, when I have the call last week, I was coming in here to start to talk about on which way or what angle we should have a look at this. Not having a closed project. We're almost done. Chief?
We brought this question up several times. We asked them several times for a direct answer on why they are not looking at other cases. This was brought up in the Chiefs' Assembly. I had, I think, 14 chiefs there asking the same question. It is very, very clear that it's said to try to solve all the problems, not just gender. The reply from them on 4 occasions were, that's your interpretation, We interpret it as just gender, and that is the only cases we are going to look at this time.
Ma seconde question, ma dernière question,
My second and last question. The department's representative said that under C3 they expect from 28 to 35,000 persons who may become eligible for Indian status if the bill were to cover all the categories you just presented. Do you have any estimate of how many new people would be reinstatees or would be admissible?
Il y a à peu près une ou deux personnes.
About 1 or 2 people in Canada only are in a position to estimate that, and we didn't hire them. Let me give you a little extra information.
Canada got 2 extensions after the McIver judgment.
Merci beaucoup. Je vais céder le reste de mon temps à monsieur.
Thank you very much, and I leave the rest of my time to Mr. Russell.
Has been pushing back in terms of, you've mentioned several times you've wanted to have a discussion. Who in the department has been pushing back specifically? Or which department, or?
You had them sitting right here a little while ago.
All the same people?
Yeah, it's the exact, that's the staff I've been meeting with. That's the same ones who met with us at the Chiefs Assembly, who made it very, very clear that they were only looking at this particular case, and that was it. But then again, today I heard about stage 2, which, like I said, I've never heard anything about that. I spoke to them, the last time we spoke to them was just Friday, never mentioned nothing about that. So it's the same, that's the same team that has been working on this from the beginning.
Were you engaged in conversations from the beginning about something that looked like a stage 2?
Nope. Like I said, there's been no consultation at all.
Other than whatever conversations you say you had?
Just to clarify, in the spring of this year, I wrote to my opposing counsel once the appeal had been withdrawn, and I said I hoped that my clients would be hearing from her clients, and she said, "Oh yes, I'm sure you'll be getting a letter from the registrar." That was sometime in the spring. The next thing I heard was that the proposal had gone up on the website of Indian Affairs. Then there was one meeting in Montreal with the chiefs that Chief Obamswin mentioned. That was September 8th. Then it was silence again until someone mentioned to me there was a bill before the Senate. Just to be clear, there's still a case before the court. I'm still the lawyer in that case. I have never, the only contact I've had has been from the clerk of the committees of the Senate. But I did thank him.
It's almost a situation of what to do now in terms of where do we go, and I'm an individual who likes conversation. I think if we have conversation and we don't withhold information for whatever reason, we are open and sharing and build relationships, that there's things that can be done. Now that's just me. I over many years have dealt with the department in different roles I've held over my career, and this is now a different role I hold as a member of Parliament and sitting on this committee. I find it frustrating what you've gone through with trying to deal with the department. I can say that I had been in previous roles frustrated dealing with the Department of back then Indian and Northern Affairs, and I just don't know where this should go right now, and I have an idea of, I know where you would like it to go, further discussion and And if I'm getting it right, the department asking the court for an extension so we can do this right.
Yes, exactly. I'm also a strong believer in communications, okay? I really believe that if we discuss these things, we can solve the problem. A one-way discussion doesn't work, you know, and I know it sounds crazy being the people who won the case trying to tell them to ask for an extension. But like I'm saying, I don't want to do this again. You know, I think we have a perfect opportunity. I think it's not time to close the door and say, well, okay, we'll move on to stage 2. We'll move on to something else. No, the door's open. We're here to discuss. Let's sit down and say, how can we solve this problem? You know, how can we sort this all out? There's no doubt about it. I mean, I see with the influx of status, I see the burden on Indian Affairs, and and I can appreciate that too. But we need to have communications.
We're out of time. Next question is from Kathy McLeod, please. We're into 5-minute questions now. Yeah.
Thank you to the witnesses. Just a quick out of curiosity, do you ever have anyone that under your citizenship code you accept that is not status?
Yes. Citizenship code isn't based on status. What citizenship code is, our citizenship code in our community is based on, it's based on a family member. So as the status system runs out, as we say, which never did figure out how that ran out, but it does run out. So if the status runs out and they, to the community, it's still a family member. So we will bring them in as a citizen.
So in the case of your daughters, is it, Mr. Deschanel?
I even went through that, because when my moms get back in '85, I was on the first citizen code they had on the reserve. I was one of them. Then after that, I got statehood, and my daughters were on the code now. And that's just try to figure out. I'm going to slide out, and then I'm going to pass the puck back to the chief. Every single day, I have new friends in Canada who write to me and asking me questions. Let me know, or let us know when you're going to start to talk with the government about the new law, about the changing of the stuff. And there I am, like a clown, telling them, I will. I'm going to tell you when. And I'm going to tell you when the machine's going to be on. I have to told them last week, well, I'm going to Ottawa, see what's been done. See, that's how we feel about that. But for the citizen stuff, yeah, they were proved. They make this certain. You were there.
So in your case with your community, it's they've been very accepting regardless of this piece. But I would say, Chief, that's probably not the case in all communities.
It's definitely. I'm very technical, no good. Okay. Let me explain some of the problems with citizenship code. In our community, we're a very open community, okay? In some communities, they're very, very closed, okay? They're even close to some of their own status members. This is individual communities, and I can't speak for them. But let me explain to you one of the problems with citizenship code, okay? Because under being a status member can own land and live on reserve and own a house, where a citizen doesn't really have the right to own land and have the same exemptions that a status member has. So let me tell you how it went with my little girl. When she was very young, when we first came out with the citizenship code, she went to school, and her friend said to her, how come you're more Indian than I am? See, little kids don't understand what the difference between a citizen is and status is. So the problem with the citizenship code is it creates racism and stereotype within our own communities, because children don't understand. And this was the biggest question among the kids. Well, why am I a citizen and you're an Indian? So there is the complications with it too. At the beginning time, I remember that my community had thought, the chief that was in there at that time he would issue cards, for citizens. And so some would have a citizenship card, and other ones would have a status card. And this is the problem that we created, was young children don't understand. So we're trying to take a real complex system and trying to explain it to children, when they just want to go to school and have fun and and be who their first cousin is, or even who their sister is, and not understanding that.
That's what they were in my family. My own kids, they were playing with their own cousin who were sterut. We have the same grandmothers, but we have an uncle instead of a hand, and they were the same kids. Like, I am more than you are, exactly like Rick. And try to explain them. You try to explain that to them, but you can, because there's no logical to that.
So you might have heard earlier, I talked about one of the communities that I represent getting a letter I don't know, it was June or July. You didn't get that same letter talking about there was going to be a consultation process?
Nope.
Okay. Can we put that first slide up that sort of talked about the actual decision? I think it was the original slide.
First,
Is that
the first page?
Am I out of time?
You're out of time, but make a nice backdrop for the next question.
Thank you.
All right, we'll move to the next 5-minute question, which is coming from Gary and Anandis Angry, please.
Thank you, Mr. Chair. Thank you for joining us this afternoon. I take your comments and certainly appreciate the frustration that you expressed today. I just want to kind of hone in on the actual decision itself, and I'm a little bit confused, so maybe you can give us a little bit more clarity. So my understanding of the particular case in question, the issue for the court to decide was the issue of gender discrimination, right, if I'm not mistaken?
Yes, there were two cases. Maybe I'll try and do this very quickly. It took me 5 weeks in court. So the thing you need to remember is that a 6'1's child is always status, but a 6'2's child is only status if the other parent is status. And you also need to understand, and this is crucial, everyone who was on the list before 85 is 6'1. Before 85, the son, so there are two situations. We'll get to Stefan's in a moment. In the Yanta case, Susan Tammy Yanta, the son of an Indian man and a non-Indian woman born out of wedlock pre-85 was entitled to status, but there was nothing in the Indian Act because the Indian Act said an Indian depends on the male line, but there was nothing to make his daughter an Indian. So we had this situation post-85 that the sons of those men were 6'1 and the daughters were 6'2.
Right.
So that was the first thing that's being cured by this judgment.
Right. But in terms of the judgment itself, because I'm trying to get a understanding as to, because I think we can agree that the Indian Act is problematic on a number of levels, and I think it's there's a desire, I think, by many to in fact even eliminate the Indian Act or have it replaced with something else that would give the communities a lot more agency, right? So in respect to the actual decision itself, my understanding is that it was to deal with the issue of gender discrimination, and any and the legislation to come forward as per the February 3rd deadline is to redress any anticipated issues with gender discrimination, right? If I'm not mistaken.
Not just gender.
Well, the Justice Mouse was very clear. She said, I have 3 plaintiffs before me, Stéphane Deschenaux, Susan and Tammy Yanta. I can only rule on their cases. Then she added the passage that we put up on the screen. She said, nothing is stopping Parliament from playing its constitutional role to cure charter violations that it sees elsewhere in the legislation.
So thank you for that clarity, and I did read that. So my understanding is that the bill before us, S3, addresses the issue of gender inequality as it in respect to registration, and any other issue is outside of the issue of gender, and certainly perhaps charter related. But that is not specifically defined in the ruling, right? So my question to you really is that at this stage, we have a deadline of February the 3rd. At this stage, what do you expect us to do? Because the court doesn't have to grant us additional time, right? So at this point, the court could actually not based on the ruling, if it stands, they could basically not register anyone applying for registration. So we don't want to have a state of confusion. And as such, the bill before us does address, I think, comprehensively the issue of gender discrimination, from my understanding. In terms of going beyond that, I think that's where the consultation process certainly probably need to do a better job in reaching out and being proactive. But the second part of it is what we're really talking about. Just 30 seconds.
But the problems we have identified aren't even in that consultation. And the second stage of consultation is a shopping list so long, it will take years to get through. And my final point is, I really don't think, for having been before for 5 weeks, I don't think Justice Mass would mind if Indian Affairs came before them and said, we'd like a little more time to get it right.
Thanks. The final question for the panel is coming from Arnold Viersen, please.
Thank you, Mr. Chair. One of the things my question was, I think it got answered already, when you kept referring to they, and that was the panel that we had just before you. That's when you say they, that's who you're talking about?
Yeah, I just apologize because I don't remember all their names, okay?
Oh, okay. Yeah, because that's my my conundrum all the time, is that it's sometimes a little bit of a faceless organization, INAN. It's never easy to pin down who we're talking about, or where the hard spot is to push on, essentially. And then you said you met with a number of chiefs.
Well, it was a chiefs assembly that we had.
Okay.
And they had asked us if they could come to talk to us at the chiefs assembly. So we had made it very, very clear that it would not be a consultation. It would just strictly be an information session, and that's what she said. It'd be an information session, which at that time we didn't really get any information.
So the chiefs assembly, is that part of AFN?
It's part of the QFN.
QFN.
The FN and QL.
Okay. So when we had the folks before you up here, they said that they've dealt with a number of the national organizations. Is that, in your opinion, is that considered consultation, or is it?
Well, again, they stated that they had consultation with several communities and several chiefs, and even on the national level, we've reached out, and we can't find anybody they've spoken to. So I had asked them for a list of communities or people they had spoken to or who they consulted with, which, being the people on the case, we would have thought that we probably would have been the first people they would have consulted with. Yeah. And they, to this date, still have not got back to me on anything.
Okay, interesting. Getting back to so AFN and then regional chiefs, and then also chiefs for individual treaties. I'm part of Treaty 8, and we have an individual chief for that. Would you say that speaking to those individual bodies, is that considered consultation, or were you looking for a sit down with? It's obvious. That seems obvious, but would you say that had they gone to more your regional chief or to the AFN chief, Perry Bellegarde, would that have been appropriate?
Well, normally they would meet with a group of chiefs. Normally they would meet with us all at the same time. Okay, at the chiefs meeting.
Okay.
But like I said, this has never been done. Okay, they did meet with us.
Okay, so that.
I mean, if they met with individual people.
Yeah.
That sort of defeats the purpose now, doesn't it?
Yeah. Yeah. But
they can tell me that person said anything.
You said you met with a group of chiefs recently?
No, when we had the Chiefs Assembly, they came, the Quebec Chiefs, they came to, and we made it very clear, and they made it clear it was not a consultation. It was only strictly an information to say, well, what they thought or where they were at.
Okay, so that was an Assembly of Chiefs meeting.
Yes, of Quebec, yeah.
Okay, which they didn't organize.
No.
You organized, and they showed up.
They basically called us and asked if they could come and have a few minutes and explain what they were doing and where they were going, and if we had questions. Well, we had asked them several questions. We basically got the same answer that you guys got. We'll get back to you. Okay. Never heard anything back yet. That was at the time when we explained to them that, and I made it clear to her. I said, you never consulted us. You never came to it. You never asked us anything. Mm-hmm. And now you're telling me that you got this February deadline date that you've got to live up to, and there's nothing you can do about it. And I suggested at the time, I said, you know, I'm sure that if you asked the courts for an extension for we could close all the files instead of closing one, going back to court and doing it again. And at this point, and as of Friday, she basically told me, no, they're not asking for an extension, which I find very strange because I made it very, very clear that if they didn't ask for an extension and we didn't solve all these problems, that we were going to be right back in court again. And she said that was fine.
So this meeting that you had was, in your opinion, the first date, and they thought you got married.
That was the very first tip. That was exactly, you got it.
Okay. Interesting. I don't really have any more questions, Chair, so I'll cede the floor.
Okay. Thank you very much. Much appreciated. Well, that brings us to a close to this panel. Gary, did you want to?
I'd like to move the budget.
Great, thank you.
Study.
Let me just say thank you. You can. I appreciate your testimony very much. The committee does, as well as a whole. We have 2 minutes of committee business to do while you pack up your business.
If I could just say, I would like to thank you all for having us come here today. Okay. Thank you very much.
No, please, Mike. We're still in session. Please come and just 2 minutes, and then you can have conversations. Okay. Mike. Thanks, buddy. So we are in a situation where we're inviting witnesses and paying for them, and we have more coming in the weeks ahead, and we need to pass a budget. So that budget has been passed around. If I could, I would entertain a motion. Gary, put a motion to approve the budget as presented.
Yes, I move.
Second, David. Everyone seems to be in favor? Okay, very good. Budget is passed. Okay, now you can greet the guests. Thank you very much. Motion to adjourn. Adjourned.